Can a child who's 12 years of age or older choose which parent he or she wishes to live with in a child custody dispute? Hi there, it's Greg Housewirth, board certified family law specialist here in Fort Worth, Texas. And that's a question I get from a lot of clients in divorce and child custody cases, especially modification cases that have occurred several years following a divorce when that child has reached the age of 12. Let's break the conversation down this way. The Texas Family Code requires that in a custody case, the court shall interview a child aged 12 or older as to that child's preference of primary conservator. So that usually establishes where the child's going to school, establishes, who's going to be the primary parent, also establishes in many instances who's going to be paying the child support. So it's a hot issue in these types of cases, but it may not be all you think it is. What I tell my clients is this: when the court interviews a child, that's a piece of evidence. That's not the entire case. There may be other evidence for the court to consider. Usually the court will hear the testimony of the parties as to their concerns, as to their home lives and their situations, and then at the conclusion of the testimony, ask that a parent bring a child down to the courthouse for that interview in the judge's chambers or the judge's office. Also, whether or not a judge goes along or follows what the child is recommending, I say it's on a sliding scale. And by that I mean this. Say, for instance, when a 12-year-old comes in, child's in the 6th grade, hasn't reached full physical maturity yet. When a judge interviews that child, typically that judge will take that child's statement into consideration, but that preference from the child probably isn't going to be the controlling factor. The court's going to rely on other testimony and other evidence that's been presented in the case. And that makes pretty good practical sense. I'd ask you this: how many really big decisions in life do we let a 12-year-old make? Not many. In contrast, if the case involves, let's say, a 14, 15-year-old, 16 and 17, that's a different story. So if we have a child who is, say, for instance, a sophomore in high school, driving, and that child is able to come in and to give an interview with the court and state clearly the reasons for wanting to live with one parent or another, chances are fairly high that the court's going to follow that child's preference in that situation. So the takeaway from the conversation is this: the child stating a preference in chambers carries different weight depending on the age, the maturity of the child, and the overall circumstances of the case. This would be a good time to visit with an experienced family law attorney to know more about the situation, know more about your case, and how it will eventually play out in a Tarrant County Family Law Court.